Hi everyone, this is Chad Granger, Regional Advisor for PrimePay's Broker Concierge Program. And this is the February edition of the Broker 315, that is 3 aspects of one strategy in 5 minutes or less. As you may recall, if you listened to last month, I did a focus on compliance. And remember our equation, compliance equals retention or new business. And today's focus is going to be especially on HRAs and compliance. So HRAs are employee welfare benefits, and therefore they are also subject to ERISA. Plan sponsors must comply with the ERISA claims procedures and appeals rules, which are spelled out in the SPDs. But they must also comply with the record retention rules. So those rules are that information, whether the group is over 100 or under 100 plan participants on day one of the plan, they still must keep all the information that would typically be on a 5500 filing, and they need to keep that information for not less than 6 years. So just to repeat that, regardless of group size, if they're under or over 100 plan participants, they need to keep on file the information that would typically go in a 5500 filing for not less than 6 years. With regard to HRAs and SBCs, an HRA does have its own summary of benefits and coverage under ACA, so it must be distributed to the plan participants, just like any other line of coverage. But HRAs have this peculiar little feature called Cori Fees. So any plan sponsors of an HRA must file a 720 form and pay Cori Fees on or before July 31st. Those fees apply to policy and plan years ending after October 1st, 2012 and before October 1st, 2019. So in other words, for 7 full policy or plan years. If you have a client that's running on a calendar year, then the fees are really applying for years 2012 through 2018. And then they're supposed to end. So HRAs and HIPAA and all the related high-tech rules impose numerous requirements for protecting health information, which is one of the reasons that we generally discourage a group from administering their own HRA because for the most part, they don't have the things in place to protect that information. But some still do it. And then finally with HRAs and Cobra, generally speaking, employees that had an HRA as part of their plan benefits have to be offered it and to their qualified beneficiaries, even if the HRA includes a spend down feature. Also, generally speaking, employers with an HRA have to offer Cobra beyond the current plan year. So the HRA funds, the Cobra participants should have access to them for up to the maximum coverage period that Cobra allows. Same thing would apply for if an employee has access to unused balances, any additional accruals under the plan, they have to have access to those. So just keep that in mind when you're discussing an HRA option for an employer that maybe is not familiar with them. And then lastly, the Cobra rules for group health may be difficult to apply in the same way for HRAs. So that's also something you want to look at, particularly how would you calculate a Cobra premium when an HRA is involved. Well, that was just under 5 minutes. So if you have any questions, if you'd like to talk about our Broker Concierge program, my contact information is there. You can reach me, or if you're in another part of the country, you can reach one of my associates there. And we'd be happy to talk to you about how we can help you, help your clients, retain your book of business, and expand your market share. Thanks very much. Have a great day.